Yesterday, my lord, I was reading section 7 and tried to make submission that if there is no agreement reached between the parties, there is no choice for the Union of India to not to appoint him. In this light, my lord, kindly allow me to read the order passed by the Honorable Supreme Court. Before that, my lord, the revocable judgment law is not the impugned order before the Honorable Supreme Court of India passed by the division bench of this Honorable.
Which judgment are you placing?
Yes, my lord, this is the Supreme Court judgment, my lord, that is Exhibit 11,
Exhibit?
that was executed before. It is in the appeal of 2034-40, the next, by which the
You see,
arbitrator.
we are only picking up two files, right? So whatever has been exhibited before the court, you just mentioned. Don't refer to other appeals, otherwise we will get.
Very well, very well, very good.
Which judgment? Which is the exhibit that you
Yes,
have?
yes.
Exhibit number?
Exhibit number, my lord. Order number.
Exhibit number?
203, it is there.
You must be knowing the exhibit number.
This was not showing in exhibit, but by that order, arbitrator was appointed.
Okay. In which record this order is there?
It is FA number 203 of 2014.
Where is it annexed?
Just after the memorandum of appeal, order is annexed. Before the award. Number 203 of 2014.
इनको बताइए कौन सा डॉक्यूमेंट?
I have given you the hard copy of the same.
उसमें तो नहीं मिला. Anyway, this is what you are referring to.
Yes, ma'am. By this order, this arbitrator was appointed, by Honorable Supreme Court of India. This order was challenged, passed by the division bench of this Honorable, declining my request for appointment of the arbitrator.
Where is the order of the court?
The High Court below.
Yes.
That is not there, but it is reported below.
CWDC 2273.
Yes, ma'am.
Where is that order? Show us.
In the meantime, allow me to read this order.
What was the name of the party? 2273 is within Mehta.
Virendra Mathur. A detailed order was passed. Whatever they are arguing now, all these things were argued before the High Court, and that was not accepted by the Honorable.
First, you place the writ order.
Yes. I should read from the start.
No, you just tell us what was the matter.
Tell me what.
Petition number 1 to 20.
Paragraph 3.
You just read para 1 and then.
Yes. The petitioner number 120 who belongs to court building on their behalf of 753 land of 74 village had filed this petition praying for reversing of the notification issued on 18/11/1993 by the state government and seeing the earlier notification dated 5/6/1993 issued on the basis of the letter of the district Karachi dated 30th/10/1993 and restore the notification dated 5/6/1993 issued for appointment of the arbiter in respect of all the land user under section 8(1)(b) of the Constitution of India. Here, my lord, the duty commissioner, after having found that all earlier, my lord, the notification was issued for certain persons, but duty commissioner was found that other land
That
user-
notification was also issued pursuant to an order of the High Court.
Yes, sir.
Which is that notification?
That is not here, my lord.
You don't know the number also.
I will find out. So, I am just saying, you know, the deputy commissioner himself, the competent authority himself, included the name of the all the person. He found that it should not be restricted to certain person; it should be to all person in the that mentioned in the that notification. It is, Lord, in the facts it will come. The state of Bihar, now Jharkhand, on requisition of Defence Department of India, acquired a vast tract of land in Port village, namely Sugnu, Gadi, Lalganj, Kaduna.
This has already been placed.
This judgment, I am just saying, I am not listening, I am saying this was the division bench judgment where all the argument now they are taking have been argued, the petition was dismissed, but this order, against this order, special leave was granted by the Honorable Supreme Court, so this order does not add on today, does not exist, it's merged with that order.
They are not relying upon this.
No, whatever argument now they are arguing, all these arguments are here. Even Munsa judgment, by relying on Munsa judgment, the High Court has discarded my plea. Supreme Court said, so now man, allow me to read that Honorable Supreme Court of India, because their argument on three limbs. First, most of the ground milord in appeal and before the arbitrators, they said it is restricted to only 20%, not for all person. Second, they are saying, milord, that they, whatever amount they have given, that is sufficient. No additional amount should be granted to the petitioner. And third, they are saying, milord, solicium and interest should not be granted to them. Only three limbs of argument are there. I am on first limb of argument. They are wrong in saying that arbitrators should decide only against the 20%, not all the person their name in notification. Kindly allow me in this slide, Lord, to read this very small order, Lord, to this Honorable Supreme Court. By reading this order, I will tell you, Lord, if they did not go for review of this order. So now, reopening those things is amounts to interference of the order passed by the Honorable Supreme Court. Kindly allow me, my lord, leave granted, being agreed by the judgment and order passed by the High Court of Jharkhand and Ranchi CWJC 273 of 1994, dated 10/1/2008, the appellants are before us in this appeal by special leave. By the interim judgment and order, the High Court has rejected their petition wherein they had sought for a simple and equitable relief of appointment of an arbitrator as provided under Section 8(1) of the Acquisition and Acquisition of Movable Property Act 1952, the Act foresaw. The factual matrix of the case reveals that lands of the appellants and similarly situated persons have been requisitioned by the central government under the aforesaid Act. Thereafter, since an arbitrator was not appointed as required under the Act for deciding the compensation payable to the land user who have lost their land pursuant to the requisition made by the central government, some of the land users had filed the petition before the High Court inter alia requesting High Court to direct the respondent to appoint an arbitrator to decide the claim for a reasonable compensation for having lost their land. The High Court, considering the plea of the petitioner therein, had in fact directed the respondent to appoint an arbitrator, a retired High Court judge, to consider the claim of the petitioner in the said petition. Similarly, situated person had approached the state government to issue an appropriate notification referring their matters also before the arbitrator. The state government, by issuing a notification dated 5/6/1993, has referred the case of all the persons notified under the notification for adjudication. With my Lord permission, I call here Lord the state government itself to all the persons claimed by for compensation by an arbitrator. Subsequently, the said notification came to be withdrawn for the reason based on them alone. Aggrieved by the action of the state government, the petitioners went before the High Court in writ petition number 2273 of 1994. The High Court, in our opinion, kindly mark these two words very strangely has dismissed the writ petition filed by the petitioner. That is how the appellants inter alia claiming that they have filed this appeal in the representative paper. Lord kindly, again this one representative capacity, the SLP was filed. That was accepted by the Honorable Supreme Court. We have heard Mr. Raghu Patil, learned senior counsel for the appellant, and Mr. Paras Purav, learned additional solicitor general appearing for the respondent. In our opinion, it may not be necessary to go into the detail of the case, since we are of the considered opinion that High Court was not justified in rejecting a reasonable request made by the petitioners. So our request was found reasonable, and the action of the High Court was found not justified. In writ petition number 2273 of 1995. At this stage, we also take note of the fact that persons who have lost their land because of the requisition are over illiterate scheduled tribe people. In a matter of this nature, in our opinion, the true concerns would have prevailed on the respondent who have accepted the reasonable request made by the appellant instead of arguing the matter on technicality. So, Lord, the assertion has also been charged, Lord, upon the respondent why you are not accepting this plea. Para 7.
I have read it.
I view of the above while allowing this appeal to be restored and order notification pass issued by the state government dated 5/6/1993. We are informed that arbitrator appointed under the aforesaid notification is no more. Therefore, we direct the state government to appoint a new arbitrator, retired High Court judge, to decide the lease between the parties. Can you mark me on lease? What is the lease? I will explain later. Lease between the appellants and others also in respect of those persons who have lost their land pursuant to the notification issued by the state government dated 5/6/1993 as expeditiously as possible at any rate within a month of time from the date of receipt of this court's order. We further request the learned arbitrator who may be nominated appointed by the state government to decide the lease between the parties as quickly as possible in view of the fact that the acquisition of these lands was done by the Union government way back in 1972. We have not expressed any opinion on the merit or demerit of the case of the parties of the lease. So, my lord, they are taking this line. As per my understanding, Lord, lease between the parties, that how much we are affected by not getting an appropriate proper compensation. They are saying we have paid the proper compensation. So whether the proper compensation has been paid or not, that is the least.
See, before the arbitrator, everything remains open. It was just an arbitrator who was appointed. You cannot say that the arbitrator cannot go into the issue as to whether the claim should be enhanced, not enhanced, what is the status of the parties, whether they have accepted the award or not, whether they have filed any claim or not. These things, we cannot restrict the jurisdiction of the arbitrator.
Kindly appreciate.
I have understood your argument. I am
appreciate-
expressing what I feel about
Yes,
it.
Lord. Absolutely, I am telling Lord, in this act, Arbitration and Conciliation Act is not applicable.
Yes.
So section 9, Lord, where the Arbitration Act you can take plea, this technical plea, whether you are entitled or not. Here, my lord, I will reading, my lord, I will read. Arbitrator has to decide the claim made by both the parties.
That's
That's the restriction of the arbitrator. Before that, not coming to the act. Yesterday, not one judgment placed by my learned senior, the constitution bench judgment. Kindly mark the only one line paragraph mark. Kindly take note. Paragraph 6, line 4. This is judgment, my lord. Union of India, Kamalabai, Harjivan Das Parekh and others. Paragraph 6, line 4. Section 8 of the Act has a marginal note, principle and method of determining compensation under clause A of subsection 1 of the section 8 compensation to be paid in accordance with the agreement if any reached between the owner of the government. If no such agreement can be reached, an arbitrator, and you mark this line, has to be appointed for the purpose of the terms clause B. So this is the constitutional judgment. They are placing that two judgments. That judgment cannot be read in light in view of this line of this honorable constitutional bench. Those two judgments, my lord, that is per incuriam in the light of this constitutional bench judgment. So I summarize, my lord, that if whether we have paid money or taken money, if we are not satisfied with the money, once the arbitrator has been appointed by the Supreme Court, it's deemed that we have not satisfied with the money, there was no agreement, and now the arbitrator, before appointment of arbitrator, nothing can be argued. They have taken the money, they have not taken the money. Once the arbitrator has been appointed, it's deemed to be taken that we have not taken the money with our free will. We are not in agreement of the money given by the government. Then, my lord, kindly have, my lord, allow me to read section 8. Once the arbitrator is appointed, how to proceed? I am placing, my lord, 8 subsection D and E. At the commencement of the proceeding before the arbitrator, the central government and person to be compensated shall state what is their respective opinion in their amount of compensation. So the list which I have, my submission, ultimately my lord, prerogative to Lord, it is list what should be the compensation given to the landowners. Then Lord E, the arbitrator shall, after hearing the dispute, make an award determining the amount of compensation which appears to him to be just. So it is, my lord, the power given to the arbitrator, just and specifying the person and person to whom such compensation shall be paid, and in making the award, he shall have regard to the circumstances of each case and provision of subsection 2 and 3 super as applicable. so far as they are applicable. It is not again, my lord, it's mandatory for the arbitrator. So far as they are applicable, in my reading of this section, the arbitrator is given an authority to apply his mind as per the circumstances of the case. There is no method the arbitrator should go like this, Lord. That is my humble submission. And kindly note, Lord, against this Supreme Court order, they have not filed any review petition. They have accepted the Supreme Court review petition. Lord, we have filed before the arbitrator our written state argument.
What is the meaning of a just compensation?
Just I was looking, Lord, yesterday in the meaning, the dictionary, what is the meaning of just means not fair, reasonable, according to the prevailing circumstances.
Just means reasonable.
Reasonable, fair. So the first meaning is fair.
Fair and reasonable, right? So far as the computation of compensation is concerned,
Yes.
Is there any specific method provided under the Land Acquisition Act?
Land Acquisition Act, my lord, the section 23 market value, which was, my lord, that is the series of judgments that governs the field.
So here also, when we talk about just, fair and reasonable compensation,
Yes.
is it relatable to market value?
Yes, of the market value he has to ascertain.
That's right.
At the time
so
of
the
acquisition.
parameters of computation
Yes.
in case of Land Acquisition Act
Yes.
and in case of this act
Yes.
is one and the same.
Yes.
Parameters of computation are the same.
Yes.
Correct? So,
Parameter I will come, my lord, the latest judgment of the Honorable Supreme Court, the Okhla Development Authority. In this, similar the legal judgment passed by the Honorable Supreme Court and the various High Court, that governs, there are various, the future perspective, area of
there
location.
are the parameters. So
Maybe.
same parameters can be applied.
But court says that even though that is not final, even though court is saying that is not final, it depends upon each and every case circumstance.
That's right. But some guideline has been laid down judicially.
That.
Otherwise, in the act there is no guideline.
Otherwise, arbitrator has to take note of that.
That's
Then, Lord, we have filed a written argument before.
so. Let us see the criteria.
Yes.
Let's complete this part.
Yes.
What is the method of computation? Which judgment are you relying upon?
We have filed a number of judgments.
No, you see, the
I
judgments.
read only one
The
judgment.
judgments which you will not place it before the court, I will say that it has not been placed.
No, why would we have placed, my lord?
Whatever judgments you will place, only those judgments will be taken care of. Merely because you file judgment, that is of no consequence.
Okay.
That is of no consequence.
Yes.
You have to place the judgment. Which judgment do you want to place?
Okay. I thought, my lord, I will place the judgment at the same.
No, you just, because it is the parameters, which parameters are to be taken into consideration.
Is this a copy of the 2024 SCC online SC 1699?
The judgment is not there in the bunch. You have a copy of the judgment?
Yes.
2024 SCC online, Page number?
Page number, my lord, 1691.
1691. Para number?
Para number, my lord, 35.
35. This is Okhla judgment.
Yes, ma'am.
Yes, please skip to.
Yes, ma'am.
Mode of computation, right? Which paragraph are you referring to?
35.
Kindly read.
Characteristic of the land, the valuation of land is undeniably influenced by the inherent characteristics of the land. Below the advantages feature that enhance its accessibility, utility, tends to
Because
command higher.
my काम नहीं कर रहा.
I'm sorry. The valuation of land is undeniably influenced by its inherent characteristics. The valuation of land endowed with advantageous feature that enhance its accessibility, utility, tends to command higher market price. Thus, the greater valuation in comparison of land lacking such includes key factors contributing to such features include connectivity by roads, other means of transportation, the size and shape of the land, ability of essential utilities such as electricity and water, wilderness and labeling of land, surface, mix of frontage, nature of the status of the surroundings, area, etc. In addition to the characteristics, the valuation of land are also influenced by potentiality. Lands with the potential to be used for commercial or residential purposes that are located in near a developed area, which are approximate to tourist destination, are perceived to hold greater value in the future. Consequently, landowners may anticipate higher future price and accordingly demand higher sale prices compared to the land lacking these attributes. Accordingly, these features are lead to an increase in valuation. Factors denoting market sentiment or to diverse for land valuation, even if a particular piece of land possesses all desirable features, its valuation can still suffer due to market condition at the time of publication of some unfavorable factors such as economic recession, political instability, security, investment, and real estate crisis can market impact the perceived value of it. Whereas these exceptions, economic and political factors may also be considered when assessing land valuation. Then, other
These are the factors to be. These are the
Here are-
factors to be taken into
Yes.
consideration. I want to know the method of computation. Like examples of savings are to be taken into consideration. And there are many other things also. Circle rate, if at all, is to be taken
in
into
that hands,
consideration.
one latest judgment, my lord.
Which is that these are the basically the
factors to
factors to be taken into
This is
consideration,
the
right?
situation of the land.
It is not the mode of computation. Factors to be taken
Because
into consideration. And the whole idea is to find out whether the method which has been adopted by the learned arbitrator has been recognized by law in any judgment, or he has adopted his own method. Because I just want to know, is there any such kind of method that for 10 years, 15 years, you will count it down by 10% each and then increase it by 10% each? Is it a permissible method of calculation?
Not,
Under law. So just cite that judgment,
yes,
which gives a method of calculation.
yes, yes.
These are the parameters, well-known parameters.
Yes. Lord, I was reading. Kindly take note of that. We filed our written argument before the arbitrator, and in
before we enter into the merits of the case, I just want to know from you what are the methods of calculation in case of NAC. General principles. First, you place the principles, then we'll see the facts of the case. Because the principles which a learned arbitrator has appointed, I have not come across this principle yet. So I just want to know whether this kind of principle is otherwise permissible under law, because the Act is not giving any guideline. Act is not giving any guideline.
One recent judgment, my lord.
So which is that judgment? Please place it. You just finish your argument on the principles of law so far as the method of computation is concerned.
I bore on, because I thought, my lord, I generally.
I know
Generally-
you must have prepared it in a
Generally,
particular
my lord,
way.
in our, where we first place the.
We have seen the facts for
No,
last
no,
2 days.
No, my lord, that those some certain facts have been.
We will see that. We will see that. But
In,
I
in,
just
but
want.
I clearly submit, my lord, I yesterday since I was when I was trying to find out something. One judgment, my lord, we find a recent judgment where 6-7 year de-escalation method has been adopted by.
Which is that judgment? And under what circumstances this kind of method is adopted? Under what circumstances this kind of method is adopted? I think, I assume so, that such kind of method would be adopted in a circumstances where there is no comparable sale available
Yes.
for comparison.
Yes.
When nothing is available, then some remote sale can be taken into consideration by computing the de-escalation or escalation of the prices as the period may be. But once there are materials of that particular time, then can a average be taken? Or it is like, one after another. If first method, if exemplar sale is available for that period, nothing else is required to be looked into. Why should anybody go to see anything else apart from the fact that proximity and these factors, what all factors you have said? Apart from that, nothing else is required to be considered. But the learned arbitrator has adopted a hybrid mode. He has taken de-escalation, he has taken escalation with respect to one SAIDI, de-escalation with respect to another SAIDI, and he has come up with multiple acceptable documents, and then the calculations made, and then he takes an average. Is this kind of method?
May not be, my lord, clearly submit, my lord, may not be. But, my lord,
Hybrid approach.
with caveat, my lord, with great respect, that one sale which yesterday was happening in the 1971.
You please refer to that judgment which you have, recent judgment you are saying, where is that judgment?
My lord, I am Ram Kishan.
Anyways, if that judgment is not there with you, we can't do it. Yes, continue.
Yes, I was looking I was asking judgment. One judgment will not be filed, but what is the taking issue? Judgment taking issue. It is not 2008-17 SCC 133. Sardar Govinder Singh versus State of Uttar Pradesh.
Which para?
Lord, it is paragraph 18, my lord.
Para 18, this is concurrent finding of the tribunal
That
and the High
tribunal
Court.
was affirmed.
No. There was there. 18 says there is a concurrent
Yeah,
finding of
there's a
tribunal and the High Court.
Yes, my lord.
We are still in the High Court.
Can you allow me to read para 13, my lord, from 13. Each case related to an accusation in the year 1979, they relied upon award related to an accusation of the year 1969. The general increase between 1969-79 can be taken to be around 8 to 10% per annum. If the said increase is calculated cumulatively, we find the total increase for 10 years would be around 100%. Therefore, the assessment by the tribunal affirmed by the High Court does not suffer from any impropriety. The other evidence also broadly supports such an increase. There is nothing to show that market value could be less than 3 per square feet equivalent %. Therefore, we find need to reduce the market price fee at the.
You read para 12 also.
Yes. On ONGC Limited, Ramesh Bhai Juman Patel, this court held that in regard to the urban city urban area, in the absence of other acceptable evidence, the cumulative increase of 10%.
In absence of other acceptable.
Yes.
It is not that everything can be taken in a hybrid.
No,
In absence of acceptable evidence. Once there is an acceptable evidence with regard to the date, area, place of acquisition, by way of example, then under such circumstances, where was the occasion for the learned tribunal, arbitral tribunal, to adopt this 10%, 15% increase? This is what I am asking. भाई फर्स्ट नहीं आए तो सेकंड से चलेगा, लेकिन अगर फर्स्ट है तो सेकंड से कैसे चलेगा? समझ आएगा? बस. This is the maximum I can explain what is going on in my mind.
In that also going in my mind also, because whether the arbiter which has adopted this practice, whether it is permissible in law or not, I am just on that I have in my mind. My challenge to this appeal will not weigh that I have placed the earlier awards, earlier judgments, those were how to have considered before fixing the market value. Even though the arbitrator is wrong, taking this kind of method.
First, let us be clear from your part. that the method adopted by the arbitrator is incorrect. Do you want to see that?
No, my lord, for that I need at least, my lord, half an hour time so that whatever I will submit, my lord, that should be correct. I should not make any incorrect statement.
That's right.
But I am saying, Lord, that's why, Lord, I am saying, Lord, why my challenge to what extent I have challenged this arbitrator award, way that proper market value has not been assessed, ignoring two of my valuable documents.
Two valuable documents have been ignored.
Ignored
Which
all
are exhibit?
exhibit, my lord, which are exhibit 12,
Exhibit 12 and
Lord, exhibit 12, I am more harping on this, and exhibit 4.
these
And
two
the-
documents have been discarded.
Discarded on wrong assumption. A perverse finding, I can say, with great respect. And these two, because my lord, the earlier judgments, nearby village or award, and moreover, which has a validity sanctioned by the higher court, is, my lord, one of the best criteria to fix the market value.
These are the two judgments.
Yes. My lord,
Yesterday
I
also we had noted it down.
noted down, but those facts, my lord, somehow escaped, which I want to.
Okay, just a moment. Exhibit 12.
12.
It relates to acquisition of
No, it's a judgment of Honorable Supreme Court of India.
Relates to acquisition
relates
of-
to the acquisition of Ward number 3 of 1954.
Ward number 3 of 1954.
Ward number 3 of Ranchi municipal area.
Okay, but of the year 19, date of acquisition is
I
1954.
am giving the exact date. my lord.
We have noted it down yesterday.
There is no this also.
This we have noted.
Yes, my lord.
So this is exhibit 12.
Yes, but my lord, why the arbitrator has not been considered this document. Arbitrator can discard my document, giving us region, but not on that region, which region the arbitrator has discarded is absolutely
The
wrong.
first appeal can also reject a document giving a different reason. With 1954 document acquisition date,
Yes, ma'am.
no, nothing can be done.
Let me allow to place that.
Yes, I am allowing you. I am allowing you. It's not that I have not closed my mind, but I am just.
Ultimately, my lord, to have to decide, my lord.
What about exhibit 4?
Exhibit 4, my lord.
Date of acquisition?
Date of acquisition. Exhibit 4, the 28/8/1971. This relates to ward number 5 and 6.
It's in Doranda.
My lord, the
This is
evidence,
in Doranda.
evidence has come. Gari falls under ward number 4. That evidence I am.
What falls under?
Ward number 4, the land is in question,
Is in ward number
ward number 4. That has come, my lord, in the evidence of their evidence, my lord, it's a DW3 DW3 Milord, para 8. Page number 2 Milord. This is deposition of Abhay Narayan Ambasht. This is Milord.
He's a claimant.
District Land Acquisition Officer. The 28th September 13, deposition was recorded on behalf.
Abhay Nandan Ambasht.
Yes, Milord. Abhay Nandan Ambasht. Paragraph 8. Over the page number 2. That village Gari is within ward number 4 of municipal corporation. I'll place not this to here why the arbitrator has not considered this document and why the reason given by him is sufficient or not. 4 and 5 Milord, one acquisition sanctioned by the Milord, the approved by the Honorable Court, and ward number 3 is also by the Honorable Court.
All the villages are in ward number 4. He only says village Gari is important.
They are saying contiguous, but
But
evidence.
ward number can change, even if it is contiguous.
It
Are
is-
they all falling
It
in
is
ward
not on
number
record. For to here. Milord, kindly have Milord the award first.
internal page 25.
Milord, the internal page 25.
Bottom, exhibit 4.
The claimant documents which are not relied by this tribunal are: first, Exhibit 4. The said exhibit is judgment of the Honorable High Court in Appeal number 220 of 1997 R 6290 in relation to the land situated near railway station, bus station which were acquired under the LA Act on 28/1971 and for which compensation and 2,50,000 per area were awarded. However, in view of the proximity of the said land near the railway station bus station, I am not inclined to consider this said. I would kindly have Exhibit 4 first.
Who has exhibited this document? Which witness?
This was filed by us.
It was simply filed.
Simply certified copy.